Let me ask you something. What if everything you thought you understood about living, studying, or working in the United States was quietly changing underneath your feet? Right now, in 2026, and nobody told you? Not a small tweak. Not a minor administrative update buried. Somewhere on page 47 of a government website. I'm talking about structural changes, real ones. The kind of changes that could stop your work authorization dead in its tracks, get your visa application frozen without warning, or completely reroute your future in this country in a direction you never saw coming. And here's the uncomfortable truth that most people in the international community are only finding out the hard way. By the time you hear about these changes through word of mouth, through a friend's panicked text, or through some vague social media post, it might already be too late to protect yourself. That's why I made this video. Because right now, in the middle of 2026, three enormous shifts in U.S. immigration policy are actively affecting international students, scholars, workers, and their families. And if you don't know exactly what they are, exactly how they work, and exactly what you need to do, you are operating blind. I've spent serious time digging into the actual government documentation on these changes. Not rumors, not speculation. Real policy memos, presidential proclamations, federal agency guidance. And what I found is something that every international person in this country needs to understand deeply. So stay with me, because by the end of this video, you are going to know more about the current state of U.S. immigration than most people around you, including some people who have been here for years. And real quick, before we go any further, I have to say this clearly. I am not a lawyer or a legal advisor. Nothing in this video is legal advice. This is educational and informational content only. Laws and policies change, and they affect people differently depending on individual circumstances. Please always consult a qualified immigration attorney about your specific situation. Okay, now let's get into it. Here's what I want you to picture. You've been in the United States for a couple of years. You finished your degree. You got your work authorization. You found a job. You're building your life. You feel like you have a handle on the rules because you've been following them carefully the whole time. And then one morning you wake up and something has changed. Not your situation, the system itself. A rule you were counting on. A protection you assumed would be there. Gone. Or dramatically altered. That feeling of the ground shifting beneath you. That's not hypothetical for a lot of people right now. That's actually happening. So let's talk about the three biggest changes, one by one, starting with the one that has probably caught the most people off guard. Change number one. Social media is now part of your visa record, and they are actually looking. I know that sounds dramatic, but I want you to sit with that for a second because this is not a theoretical risk. This is active policy. Here's what happened. Starting in mid-2025 and continuing aggressively into 2026, the U.S. Department of State and the Department of Homeland Security dramatically expanded the scope of social media vetting for visa applicants and immigration benefit requests. What does that mean in practice? It means that when you apply for a visa, whether that's an F1 student visa, a J1 exchange visitor visa, an H1B work visa, or really any non-immigrant visa, the people reviewing your application are now looking at your social media, not just glancing at it, systematically reviewing it as part of the vetting process. And here's what makes this particularly significant in 2026. In December of 2025, the Department of State officially expanded this screening to include H-1B and H-4 dependent visa applicants. That expansion went into effect on December 15, 2025. So this isn't even something that was announced years ago and quietly implemented. This rolled out fast, and a lot of people didn't even know it was coming. But wait, it goes further than just looking at your posts and your photos. When you fill out the DS-160 visa application form, there is an entire section dedicated to social media. You have to list every platform you use, every account, every username, handle, or screen name. We're talking about a specific list of platforms: Facebook, Instagram, LinkedIn, YouTube, Reddit, Twitter, TikTok-era platforms, Chinese platforms like Weibo and Qzone. The list is comprehensive. And the requirement is that you list all accounts, not just the ones you think are relevant or the ones you're comfortable with people seeing. Now, think about what that actually means for a moment. Think about the things you've posted over the last 5 years, the opinions you've expressed, the discussions you've participated in, the things you've shared, liked, commented on. All of that is now potentially visible to the people deciding whether you get your visa, and the guidance that's been published tells us what they're actually looking for. Consular officers are reportedly reviewing social media for what the government describes as hostile attitudes toward the United States. They're looking for signs of affiliation with organizations the U.S. has designated as terrorist groups. They're looking for evidence of involvement in or plans for illegal activity. They're looking for threats, harassment, or hostility directed at individuals or American institutions. They're looking for discriminatory or hate-based content. They're looking for anti-Semitic content, and this one was specifically elevated in April of 2025 when DHS announced it would begin considering social media activity deemed anti-Semitic as grounds for denying immigration benefits. Let that last one sink in for a second. They are cross-referencing your social media with your DS-160. If you said one thing in your application and posted something different online, that inconsistency becomes a problem. Now, there are two ways people tend to react when they hear this. The first reaction is fear. I need to delete everything. I need to go private. I need to scrub my entire online history. And I understand that instinct. But here's the problem with that approach. And this is something I want to be really clear about. The official guidance from immigration advisors is to be honest and transparent with all requested social media information. Deleting accounts or going private after you've already used those platforms may raise more questions than it answers. And if you list an account on your application and your activity on that account doesn't match what you described, that creates a credibility problem. The second reaction is confusion. People think, wait, doesn't the First Amendment protect my speech? And that's a fair question, but here's the complicated answer. The First Amendment limits what the government can do to American citizens on American soil. It does not automatically protect the speech of foreign nationals from being considered as part of a visa adjudication. The legal landscape here is genuinely complex, which is exactly why, if you have concerns about your social media history and an upcoming visa application or immigration benefit request, you need to talk to a qualified immigration attorney before you do anything else. What should you take away from this right now? A few things. First, be aware that your social media is part of your immigration record in a way it never used to be. Second, be honest on your DS-160. List all your accounts, all your platforms. Third, think carefully about what you post going forward, not out of fear, but out of awareness. And fourth, if you have a visa interview coming up, an OPT application, a STEM OPT extension, a change of status, or any other immigration benefit request pending, talk to your international student office or an immigration attorney about how this policy might affect your specific situation. This is not going away. Social media vetting is baked into the process now. The question is how you navigate it, okay? Take a breath. Because what I just described affects a lot of people. But what I'm about to tell you next affects people in a different way. People who are working in the United States, people who are trying to work, and people who were counting on a specific safety net that the government just pulled out from under them. Change number 2. The safety net for work authorization just got cut, and your EAD auto extension may be gone. Let me give you some context first. For years, and I mean many years, there was a rule in place that worked like a buffer, a safety net for people whose work authorization was expiring. Document renewal on time, before your current EAD card expired, you were automatically covered. You could keep working while your renewal application was being processed, even if that processing dragged on for months. This was called the automatic extension rule. And for a lot of people, especially those going through OPT, STEM OPT, or other work authorization categories, this was a critical protection. Because USCIS processing times can be slow, very slow. And without that automatic extension, the gap between your old card expiring and your new one arriving could mean you technically can't work. That's lost income, lost status, lost time. Well, here's the change. On October 30th, 2025, DHS published an interim final rule with a title that sounds bureaucratic, but has enormous implications. Removal of the automatic extension of employment authorization documents, and that rule went into effect immediately. What that means is that the automatic extension, the buffer, the safety net, has been eliminated for a significant number of applicants. DHS ended it. Just like that. Now, I want to be precise here because this gets complicated. The rule doesn't affect everyone in every category the same way. There are still some applicant categories that remain eligible for automatic extensions, and you can check the USCIS website for the specific list. But for many common visa categories, that cushion is gone. Think about what that actually means in practice. If you're on STEM OPT and you applied for your next extension, let's say your EAD card expires in 60 days and your application is still pending at USCIS. Under the old rules, you were covered. Under the new rules, whether or not you're covered depends entirely on your specific category and whether you fall into one of the remaining eligible groups. And here's the painful reality of why this matters so much. USCIS. Processing times haven't gotten dramatically faster to compensate for this change. So the gap that the auto extension used to bridge, that gap still exists. But now, for many applicants, there's nothing filling it. What does this mean for you practically? It means you need to be applying significantly earlier than you might have planned. Don't wait until the last possible moment to submit your EAD renewal. Don't assume you have a built-in cushion. Check your expiration dates right now. Look at your specific visa category and find out whether you're still eligible for an automatic extension. And if there's any uncertainty at all, talk to an advisor, an international student office, an immigration attorney, someone who knows the current rules, because acting on outdated information here could genuinely cost you your ability to work. There's something else connected to this that I want to mention because it operates in the same general space. STEM OPT employers are now subject to unannounced site visits. DHS and USCIS officials can show up at your workplace or contact your employer to verify that your training plan is legitimate, that the employment information you provided is accurate, and that everything is in compliance with your authorization. These visits can happen whether your STEM OPT extension is still pending or already approved, and the guidance is clear. Be prepared at all times. Make sure your employer is aware of your immigration status and understands what the program requires. Keep your documentation current. If a site visit happens and there are discrepancies between what you filed and what's actually happening on the ground, that's a serious problem. I know this sounds like a lot to manage, and it is. This is genuinely more complicated than it used to be. But here's the thing about complexity. It becomes manageable when you're informed. The people who get caught in situations like this aren't usually the ones who knew what was happening. They're the ones who assumed nothing had changed. All right, we've talked about social media vetting. We've talked about the loss of EAD auto extensions. Now I want to talk about the third change, and in some ways, this one is the most sweeping because it affects the most categories of people and it involves travel, which is something that feels viscerally real to anyone living far from home. Change number 3. The travel ban is bigger than you think, and it may be affecting your applications right now, even if you're already here. In early 2025, the first major travel restrictions of this era went into effect. Entry was suspended for nationals of 19 countries. That was significant. But then in December of 2025, a new presidential proclamation expanded that list dramatically. As of January 1st, 2026, the United States is fully or partially suspending entry for nationals of 39 countries. That's not a small targeted measure. That's a sweeping restriction that covers a lot of the world. Now, if you're not from one of those 39 countries, you might think, okay, this doesn't affect me. But I want to stop you there. Because what happened next is the part that surprises people. On January 1st, 2026, the same day the expanded travel ban went into effect, USCIS issued a policy memorandum, and this memorandum said that all pending USCIS benefit applications filed by citizens of those 39 countries are now on hold and review. That means applications for employment authorization, extensions of stay, amendments, change of status requests, pending immigration applications across all of those categories frozen subject to additional review, and then it gets more complicated. The memo also stated that already approved benefits for people from those 39 countries who entered the United States on or after January 20th, 2021 may also be re-reviewed. USCIS is going back and looking at previously approved cases, and the memo left open the possibility that even entries before that date could be subject to additional scrutiny.